Hi, my name is Salem, and I'll be talking about a bias-aware legal solution to the hiring paradox. This is joint work with Deven, Desai and Swati Gupta. In recent years, many companies have announced efforts to increase diversity. To name a few, Microsoft, Wells Fargo, and Google have all set goals of increasing diversity in their workforces. However, such actions are sometimes met with resistance. The Office of Federal Contract Compliance Programs raised concerns about potential racial discrimination in Microsoft's and Wells Fargo's plans. The OFCCP also settled with Microsoft to address hiring disparities against Asian applicants. This points to a tension in addressing discrimination and diversity. Too much action and too little action can both yield legal challenges. So before addressing this decision-making in hiring, it's important to distinguish between the different stages in hiring. Sourcing, filtering, hiring, and promotion are the four main stages of hiring, and fairness issues can arise at any of these stages. Job advertisements can be targeted at specific audiences, application rates can differ due to presumed employer bias, machine learning models can be biased due to inequalities in training data, referral hiring can lead to favoritism, final hiring decisions can be influenced by human biases of the hiring committee, retention rates can differ dependent on the work environment, and so on. We choose to focus on the filtering stage because algorithms are already widely used for screening, which means that algorithmic interventions in screening have more potential to be implemented. So next we'll talk about bias mitigation in practice. We refer to bias as any inconsistency in data that adversely impacts some group. For example, if a machine learning model is more accurate on one group than another group, that would be considered a bias. If a bias can be precisely quantified, then it can be corrected easily. For example, if all people from group 1 receive a score which is 10 points below their true ability, then the scores can simply be shifted by 10. However, bias can rarely be quantified so precisely, so what happens instead is some coarse fairness constraint or a demographic blind algorithm is used instead. So I'll give a couple examples of biases in evaluations. Amazon developed a machine learning model to score applicants. Ultimately, it was observed that the model penalized resumes which included the word women's. In other words, the model carried a gender bias. This is likely due to data of past hiring trends in the company which informed the machine learning model. Due to these biases, Amazon never deployed the system. As another example, SAT scores are correlated with family income. And students in schools with higher economic need indices tend to have significantly lower SAT scores. This points to potential issues of access and economic bias. One challenge in the field of algorithmic fairness is reconciling theory and practice. In theory, some typical considerations are that scrubbing demographic information may not be sufficient to eliminating discrimination, and that there can be trade-offs between fairness and performance. Sometimes imposing a fairness constraint can hurt performance, but sometimes it can actually help. In practice, there's another very important consideration, which is that certain hiring practices can risk expensive lawsuits. Disparate impact lawsuits can be triggered by violations of the so-called 4/5 rule, which requires that the selection rate in any protected group be at least 4/5 that of any other group. Violating the 4/5 rule is not itself illegal, but it can trigger an expensive lawsuit, which may or may not find illegal discrimination. To guard against such lawsuits, vendors of applicant screening tools often boast adherence to the 4/5 rule. So next, I'll talk about how partial orders or partial rankings can account for uncertainties and biases in data. Suppose we have 3 applicants with hireability scores of 2, 4, and 5, respectively. And suppose that these scores are predictive and free of bias. In this case, the applicants can easily be ranked, with the applicant scoring 2 at the bottom and the applicant scoring 5 at the top, as shown on the bottom left. However, direct comparisons are not always easy to make. For example, suppose there are 3 applicants where A1 has industry experience, A2 has an MBA, and A3 has both industry experience and an MBA. In this case, A3 seems better than A1 and A2, but it is unclear how to rank A1 with A2, since they have complementary profiles. So to use the language of partial orders, we might consider A1 and A2 to be incomparable. So partial rankings can arise along a single attribute as well. For example, suppose for each applicant E, we have access to some interval containing the true score of E. This might come from having multiple evaluations from different evaluators, or from confidence intervals that could be constructed using group information, or from estimates of bias, or simply from testing inaccuracies. For example, suppose 4 applicants have the score ranges shown in this diagram over here. Then we can infer rankings between applicants with disjoint intervals. Applicant E4 is definitely worse than applicant E2, but E3 and E2 are incomparable since their intervals overlap. A diagram of these comparisons is shown on the right. One kind of bias that could be used to construct score intervals stems from dataset imbalance. This is when one group is underrepresented in training data, thus making it more likely that that group will face higher error rates than a well-represented group. For example, suppose there are 4 applicants coming from 2 groups, and these applicants have raw scores that are shown in this table. We can construct confidence intervals using the number of applicants from each group in the training data, or by directly using group-specific error distributions if that is available. This might result in the intervals shown below. Now suppose we wanted to pick 2 applicants. Using the raw scores, we would select the 2 applicants from the well-represented group, A1 and A2. However, using the partial ranking induced by the confidence intervals, the top 2 candidates could be A1 and A2, as was the case with raw scores, but it could also be the case that the top 2 candidates are A2 and A4. So in this example, using the partial ranking instead of the raw scores gives opportunity to a member of the underrepresented group. Partial rankings can also be formed based on multi-dimensional evaluations. In this case, we may be able to come up with some region around these data points in which we are pretty confident that the latent qualities lie. One way to infer a partial ranking using these regions is by comparing applicants when one of the confidence regions lies completely above and to the right of the other. For example, the confidence region of applicant 1 lies above and to the right of that of applicant 3, so we can rank 1 above 3. Now, to put this into broader context, I'll briefly outline how this approach, which we call the POSIT approach, can be implemented in practice. First, one should collect past hiring data. Not only will this allow for the creation of a machine learning model if that's desired, it will also allow for data analysis, which brings me to step 2. One should quantify uncertainty and bias. If some form of feedback is available, say on those who are ultimately hired, one can observe these error distributions across groups. In absence of feedback, observations of disparate impact can prompt further inquiry into the current screening process. Next, using the observed errors and biases, one can construct a partial ranking. To make screening decisions from this partial ranking, one may need to adapt a screening algorithm to work with partial rankings. Finally, one should periodically audit the system for compliance with policy and with any desired fairness goal. So now that we've discussed the POSIT approach, I'll say a few words about the legality of making decisions from a partial ranking. In general, there are 2 frameworks that can be used to justify a hiring plan that uses protected information. One is the diversity goal framework. Under a diversity plan, an employer can voluntarily promote an inclusive workforce to attract talent or gain a competitive advantage. Importantly, such plans need not point to a history of discrimination. Affirmative action, on the other hand, refers to actions designed to overcome the effects of policies or other barriers to equal employment opportunity. Affirmative action plans can be court-ordered or can be part of a negotiated settlement or can be due to government regulation or can be voluntary. While it might be the case that some implementations of the POSET approach can be justified as a valid diversity goal, the legal landscape surrounding diversity goals is underdeveloped. So we focus on justifying the POSET approach through the affirmative action framework. But the main question we need to answer is it legal to disregard information that carries a lot of uncertainty? For example, if two applicants have scores of 56 and 57, is it okay to treat them as incomparable? To answer this question, we'll look at some relevant cases. First, we have Brunette v. City of Columbus in the Sixth Circuit. In this case, rank orderings were deemed impermissible under Title VII because the city could not establish that higher scores on the test meant better job performance. It was also found that a certain cognitive ability test could not be the sole basis for a rank ordering, despite being predictive, since it failed to measure all relevant qualities. This echoes the decision of Guardians Association of New York City versus Civil Service Commission, which found that evaluations need to be sufficiently correlated with job performance to induce a rank ordering. These findings all indicate that rank ordering should be considered a design choice in a screening system, which must be validated to the same extent that any other design choice is validated. So we know that forming a total rank ordering is not always justifiable, but what exactly is allowed in relaxing the notion of a total rank ordering? Well, one relevant case is Johnson v. Transportation Agency, in which two employees, a man and a woman, were up for promotion. The man received a score of 75 and the woman received a score of 73, both clearing the cutoff of 70 points. Ultimately, the promotion was given to the woman, and this was ultimately allowed by the court because both candidates were deemed well qualified. The court emphasized that gender could be considered a plus for the female candidate as long as it was but one of many factors considered. In other words, the employer must avoid putting too much weight on gender and not enough weight on qualification. Another interesting case is Kirkland v. New York State Department of Correctional Service. One of the findings of this case was that an employer can resort to a lottery among those who meet a cutoff in cases where rank orderings cannot be justified. This allows for some randomization in selection decisions. Lastly, some courts have allowed the practice of banding, which involves replacing a raw score, say 9, with an interval, say 8 to 10, thus allowing for some incomparabilities between applicants. Banding has only taken the form of equal length intervals centered on raw scores for the purpose of accounting for testing inaccuracies. So whether or not the banding framework can apply to more general applications of the POSET approach is unclear. So I will stop there.